Okay. Okay, Brianna, just give me the order for you.
I started recording already.
Yeah, we're right? Okay.
Yep.
So look, let's go through this PowerPoint. And yeah, we've had a little bit of admin time this morning to get it started, but we're here. So as I was saying, you know, domestic violence, family violence is an issue that we can write in depth about. There's a lot of good statistics on it. There's a lot of commentary on it, media coverage and so on. And what we need to look at really is, well, okay, well, what is the law? We already know what the law is in the Family Law Act. We have to protect children, and the protection of children comes above anything else. In relation to relationships with parents, we have to make sure the child is safe first. And that, you know, obviously goes into international law that we've looked at. But what we're probably looking at now is we get to concentrate on that idea of what steps are being taken to protect families from violence. It could well be that the custody of the child now, that matter has been decided. The parents are no longer together, they're divorced or separated or however. Domestic violence or family violence can exist also within households where there are no children, or in households where they're just siblings, or it can occur between parents and children. So when we talk about family violence, we're no longer talking about custody of people under the age of 18. We've gone wider, if that makes sense. And look, if any time people have questions or they want to say something, use the chat feature or just say something and say, Mr. Palmer, can you slow down or anything like that? Because otherwise I'll just go through the slide. All right, let's move to the next slide. Good. Okay, it's quite small. I needed my glasses. All right. Make it bigger. Okay. All right. So what we're looking at here now is obviously we start with the law, and this law is what we're going to focus on now is we're going to focus on this mechanism that exists within the criminal law system, which is where you can make the court can make an order for basically people to stay away from each other or to stop bothering each other. Okay, so the key to that is if you don't like the way someone else is treating you, or you think that you have cause to be afraid, then you can go to court and you can ask the court to make an order for someone to stay away from you. Now, look, those orders are usually called ADVOs. So, like, for instance, if there's two people in the class and they don't like each other and they want to stay away from each other, you can take it to court and you can get the court to make an order. If it's an ADVO, which is what we're looking at, it's about people who are cohabiting or in a household. So, you know, there's been a lot of work done on this lately to try and bring down, especially the number of women that are dying in, you know, as a result of violent relationships with their partner. But in the first bit of law we'll look at is what is an amendment really to the Crimes Act. So this is New South Wales law, it doesn't say it there, but it's the Crimes, Domestic and Personal Violence Act 2007. So at that time there was, you know, obviously the lawmakers, the law reform, and this is, you know, if we're talking about law reform, we're really looking at what we could say to people to improve, you know, this whole domestic violence prevention strategy. So let's read through what the law says. So it's section 17. These are the things that the court, and these happen in local courts, and usually in a local court it happens once a week, every Thursday or whatever it is Domestic Violence Day or ADVO Day, and they just line up one after the other, which gives you an idea of the number of cases that are occurring. Now the court, the magistrate needs to think about, you know, is this fair, is this reasonable to give an ADVO order against someone? It can prevent them from movement, it prevents their freedom, may restrict their access to certain things. So the court has to, Section 17 is saying, okay, these are the things that the court considers in giving a domestic violence order. So I'll just read it out and then I'll concentrate on any key section. In deciding whether or not to make an apprehended domestic violence order, the court must consider the safety and protection of a protected person and any child. So it's saying it's all about safety and protection. Directly or indirectly as a result of the defendant. So the main consideration is, if you want to quote it, safety and protection of the protected person. So what other things are to be considered by the court? Subsection A there, in the case of an order that would prohibit or restrict access to the defendant's residence. So that means, let's say for instance, a mother goes to court saying the father is abusive. The father is living in the house with them, okay? So that means then if the court makes an order, the father can no longer live in the house, but may well be his house, or he may own it, you know, or co-own it with the wife. Again, it's all about safety and protection of the children. So in a case of an order that would prohibit or restrict access to the defendant's residence, the effects and consequences on the safety and protection of the protected person and any children living or ordinarily living at the resident, if an order prohibited or restriction to the access is not made. Okay, this means so you've got to give consideration of the fact that the person may not, you know, if an ADVO is made against the father and he can't come home, you have to take consideration of any hardship that may be caused to this is section B it's reading on, so any hardship that may be caused to the protected person and any children. So any accommodation of the protected person and children and any other relevant matter. So they're asking you to be considerate of the fact that we've got to think about then where that person lives or how that person is affected. And we have to think about the hardship that might be caused because of that or anything else that's relevant. But if you look at it, the hardship could happen to the children as a result of the ADVO, which means it may not be awarded, or the hardship maybe occur to the protected person because of the ADVO. But the emphasis is we got to look particularly at the needs of the protected person and the children. Okay, and it raises lots of questions. I mean, obviously every household is different. If an ADVO is ordered against someone and it means that the mother has to move out and the children has to move out, and that will, do you know, the court has to consider all those things. In any case, it's just saying, look, we're going to give ADVOs, this section of the Act is saying we're going to give ADVOs, but we need to consider hardship caused particularly to the protected person and children. So that's against the person the ADVO is being given against. And also, it's all about the safety and protection of protected persons and any child. Is that making sense to everyone? Yeah, can you just give me a nod, a few people? Yeah. Any questions? Okay, so what you're probably trying to pick up from that bit of the Act is words like the court must consider safety and protection, the court must consider any hardship, particularly to the protected person and any children, okay, caused by the ADVO. Okay, all right, let's move on to the next slide. Domestic violence and family violence has unacceptably high social, health and financial costs for victims and New South Wales society. Okay, now these statistics are probably reasonably relevant. I mean, I did this presentation last year, so I would say the statistics are still up to date enough. These are statistics from, it would be the criminal statistics, which trying to remember the name of it, whether it's Boscar, I think it's Boscar, people who collect information about crimes. So if we look at it, 125,000 reported instances in New South Wales and 300,000 unreported. So we're talking about a large number of the population who are probably affected in some way by an ADVO. 70% male. Okay, so it's not all men, but it's predominantly men. There are some statistics there about how Aboriginal women are particularly at risk. 6 times more likely at risk, 30 times more likely to be hospitalised. So those statistics in Aboriginal households is obviously a huge equity issue there about why Aboriginal women particularly are subject to violence. And if you look at a 10-year average, it's looking like it's increasing. Now, does anyone want to suggest why it might be increasing?
Is it more like they're like doing more policing of it?
It could well be, Lucy, and that's hard because in the past people didn't recognise it, people didn't report it. So it could just be there's an increase in reporting. And you'd have to take that into account. But look, the numbers aren't going down and the numbers are still very significant, as you can see. Probably, all of the stress that's going on at the moment with coronavirus is going to see a large peak in domestic and family violence. And people have already been talking about that being an unfortunate side effect of all this quarantining and all this self-isolation. We've got at the moment 7 or 8 people that are dead because of the virus, but we may already have literally thousands and thousands of families which are experiencing high levels of violence as a result of the violence. So, it's going to be a very topical issue. All right, so, and if you look at that last statistic, that's really telling, isn't it? Domestic violence is the single greatest cause of death, ill health and disability for women under the age of 45. And, that's a reality. And I suppose when you know those statistics, you ask yourself, why isn't more being done? Or why is this occurring? And at what points do we need to make interventions into this, if that makes sense? All right, next one. So look, there have been lots of reports and ongoing reports about domestic violence. This is one from New South Wales in 2012. And I think you want to be able to, I think when you talk about this issue, you want to be able to name reports and talk about, the issue, not so much as in a case-by-case basis, although you will mention cases. But when you're talking about ADVOs, most of these cases are never reported and they're not published. Do you know what I mean? They're just magistrates making judgments. So we're going to use probably statistics and media far more than actual cases. We might mention a case, but I think for this section it's more important to use reports and conclusions and opinions about what's going on and talk about particular intervention strategies.
Sir?
Yeah, who's that?
Domestic violence cases, are they protected in courts like children are? Can you go see them?
Generally not. Generally not. You can generally go into a courtroom and watch ADVOs if you want to.
Okay.
And look, maybe considering we're all on quarantine now, I don't know what's going to happen with that. Women, particularly disadvantaged women, are going to have very little access to the courts if they close. And they aren't going to be able to make these sorts of orders. And another issue in our justice system, accessibility.
What do you think?
But if you go to a court, you would be able to walk in and watch ADVOs. Yeah, who's talking now?
Angelina.
Yeah, Angelina.
Would be the alternative to court sessions now that were closed?
Good question. I would say they're going to have to do it by video link. I would say, you can't stop policing these things, can you?
Yeah.
So, yeah, we'll do it by video link, I would say. What I would say too is, just in answer to the question about open courts, if there were children that were involved, then of course the court would be closed. If there were children giving evidence or anything like that, or yeah, but usually, it's just an open court. And so that can be very, very traumatic for a lot of women who perhaps don't want all their dirty laundry aired in the public, because anyone can come in and watch it. Oh, guess what? Janie down the road is in an ADVO dispute. Let's go down and watch it. There are issues like that. But no, they are generally open. But let's have a look at this. Let's have a look at this. Although a lot of times, I should just qualify this, there's been a lot of work done when ADVOs are happening, perhaps not to have the victim and the offender in the same space at the same time. They might be in separate areas, but that doesn't always happen. They're trying to improve those things, because it'd be very traumatic to be having to sit in a courtroom and wait for your case for however long with the person who has been violent towards you. But work is being done in those areas, basically, to try and improve it. But what did the report find? It found, okay, I'm reading from the report now, going back to the slide. The report found that the government's response to domestic violence was fragmented, complex and inconsistent, meaning we've got to get everyone working together on this. The different levels of government, the different government departments, they're not cooperating. The victims faced several different service standards and complex service pathway. That means that, maybe what the Department of Community Service, the social workers are doing, the education system are doing, the healthcare system, the justice system, the corrective services system, the police, all of these things are doing things in different ways, and they have very complex ways of going about things that it shouldn't, they're just saying this is getting in the way of the system working more effectively. And then it makes this really important point, and I think this opinion comes through very strongly right throughout as we're looking at this particular topic. And perhaps, and this is why I should also say and make the point, you can use this information on domestic violence if you want to in writing a criminal answer. So if you're doing a crime question, you can talk about ADVOs because it's a crime, okay, and crime prevention strategies and anything like that if you wanted to. Or effectiveness of the legal system, a general question like that, you can talk about ADVOs. It's criminal law, as you can see. But it says here, the system, unfortunately, focuses overly on criminal justice interventions. That means they're trying to use the approach of, let's use the police, let's use the jails, okay? Let's use the criminal courts, okay? So the focus at the moment, you might say, is punitive or deterrent-based, where we'll make a really harsh law, we'll get the police to get involved, and we'll lock them up. Punitive approaches. Whereas the real need is to support victims, to give them accommodation, to give them counselling, to get their lives together, and that's one of the problems. We use our justice system to punish people. We don't use it to really help people in need. And, what you'll see with a lot of domestic violence cases is the woman will go back to the abusive household because there just isn't the level of support. Where's she supposed to live? She can't live on a friend's couch with the 3 kids forever.
Would you say, would you say like a woman who's like reported and like gone through the court process going back to abuser, do you think she'd like deny that kind of thing like after? If you know what I mean.
There's a lot of denial, Angelina. And as you begin reading about this, you'll see a lot of people are being abused but won't admit to it, or they don't see it as abuse. And a lot of people will just say, I'll just do what's best for the kids. I'll put up with it if my husband beats me. I've just got to keep my kids safe. It's complex. And there is, there are psychological conditions like the battered wife syndrome, which, is like you will enter a certain mental state because of the violence that's been perpetrated on you. And a lot of women feel controlled. They feel unworthy. They don't deserve any better. These are the sorts of things that make it very difficult for victims. So yeah, it is complex. And what this report is saying is those people who are being abused need to be supported. Okay, and that's really more important maybe than locking people up. And locking people up isn't really working, is it? A lot of the time, what's happened in the past is police have attended homes where, they might get a report from a neighbour. They're bashing up the place. There's lots of shouting. I can hear the kids screaming. You've got to get the police car over there. The police will arrive. The police will see, obviously what they see, and they'll ask the wife or the partner to make a report, and they'll say, no, I don't want to make a report. I don't want to cause any trouble for my partner. I don't want to press charges. And they've been left, those are very difficult real issues that are faced by the police every day. Hopefully we'll get to hear from some people trying to enforce this. I'll see if I can line that up for you. Yeah, it's complex. It's complex.
Wait, sir, if the police clearly saw that there were like victims of domestic violence and also like involved children, but they were like, I don't want to press charges, would they have the right to
There is some reporting, the mandatory reporting guidelines. Right. And as we'll see now, police, when they attend domestic violence, they automatically have a camera on them, which is recorded. If the police obviously think that children are in danger, it becomes very much more, they will take action. But if it requires if someone has hit someone else, and it becomes a criminal matter of assault, it really requires the victim to agree to give evidence. Without evidence, if the person says, if the victim won't say anything and the police say, I just saw a woman who appeared to be bruised, remember, you've got to be convicted beyond a reasonable doubt. You don't have much of a case because the man could say, look, she got that bruise from falling down the stairs. She hit a door. You know what I mean? It wasn't me. And if there's no statement from the victim to say otherwise, it's very hard to prove beyond a reasonable doubt.
Wouldn't that?
So, yeah, and just to give you an idea, the vast majority, I think like 90% of all police call-outs are domestic violence. If you become a police officer, this is basically what you do most of the time. It's not running around after criminals. It's trying to go into people's homes and sort out complex situations where people are violent and abusive. And you need the cooperation of the victim, really, to do much. But as we'll see, the laws have made it easier for police to make orders if they think real safety of children particularly is at stake.
So
does that make sense? Yeah.
Yeah. So if the police sees a woman's bruises or something like that, wouldn't that give them reasonable belief to do with it, or not really? Remember,
Yes, they could say, yes, I've got reasonable grounds, but I'm talking about what action do I take then? Do I arrest the person? If I'm going to arrest the person, what am I going to charge them with? If I'm going to charge them with a criminal act, then it's going to go to court and I'm going to need to prove it beyond a reasonable doubt. But it may the police may say, I've got enough evidence here that I am going to issue an ADVO. Okay, and I'm going to make sure these two people don't. The police have the discretion too at the police station to issue an ADVO, as we'll see. So they can do as much as say you are to keep away from each other, but to actually go through the process of a criminal trial without a witness who's willing to cooperate is very hard. Yeah.
So would it be within the police's discretion to remove children from a situation where they thought that there was domestic
Absolutely.
violence?
If the police go into a household and they feel the children are at risk, they'll take the children straight away.
Yeah.
Or what they'll probably do is they will put the children in a safe place. As we keep on looking at in the law, the first priority is always the children and the safety of the children. Yeah. Which is, yeah. But as you can see, it's difficult. And look, most police officers, 22, 23, a lot of them have a gun and they like to ride around in a fancy car. They're maybe not that skilled at working out complex family problems. So, when you look at the system, probably getting the police to do much about it is, in many cases, too late. It needed to happen before then to be but each case is different, and I know that there'll be cases where the police will go in and for whatever reason they'll say, right, okay, the children are terrified, confused, we're going to put them in a safe place. But then again, how many resources do we have? Where are we going to put them? Who's going to house them? For how long? What are they going to do when someone else needs that place? These are all of the issues in the system. But let's keep going. The report identified service shortages. So that's things like accommodation, counselling, all those sorts of things across a number of areas that meant that the safety of the victim was at risk. The victims here in these crimes, we're just not giving them enough support. They're at risk. The report also found that organisations did not assess risk in a consistent manner. So it means like what the health department does isn't the same as what the education department does, isn't the same as what maybe the family court does, isn't the same as what the criminal system will do. They're all using different systems, and that no system to prioritise victims, and that there was no system to prioritise victims at serious threat. That may have changed a bit. I know that there have been reforms since then, but the whole idea and the emphasis of this report, it clearly identifies the weaknesses in the system, and I think that quote is useful. Okay? And it's saying to the New South Wales government, make sure there's a way of working out who is most at risk and what are we going to do about that. Okay, is it making sense? We'll go on to the next slide. All right, just have a look at how you're going. Anyone like to say anything? Yep. Alison's with us. Alison, how are you going?
Good.
What happened this morning at 9 o'clock?
I'm not sure.
Right. Well, it's good to have you with us now. Okay. All right. So, well, go back. All right. Now let's look at this slide. Okay. So I won't read this one out. Okay. So you can see who the main service providers here. The thing about this area of law is, remember, it's not just the criminal justice system. We're looking at this issue across all of lawmaking, and laws are made for health, laws are made for welfare, so they're all legal responses, if that makes sense. So there's some key recommendations there: prevent the violence, identify and manage threats, share information, refer on information to each other, that's sharing, assist in the legal process, enable recovery, respond to the needs, increase the safety and wellbeing of children, and make people accountable, and alerting agencies. And they developed a framework in 2014 called It Stops Here, Standing Together to End Domestic Violence. So a framework is a set of government sort of instructions or guidelines. Okay. So look, some language there to use, but we've been talking about that issue. Okay. So let's go to the next slide. Under the Family Law Act, all state and territory orders are described as family violence orders. Such orders may forbid one parent from coming within a set distance of another parent or stalking or harassing them. Okay. Now, so the Family Law Act also has within it the powers to stop parents from contacting each other or harassing each other. You don't have to go to a local court to get an order. It's a family violence order that comes from the Family Law Act. Okay, it's still supervised, I suppose, by the New South Wales. It still is supervised by the New South Wales Police, but it exists separately to what exists under the Crimes Act. Is that clear? Are there any questions about that? So you've got the Family Law Act that has powers to separate parents on certain terms, to stop them getting in contact with each other, and you have also the Crimes Act, which can stop anyone, any two people from interacting with each other.
Wait, so do you need to go to a court to get one of these, or no?
To get any sort of order that prevents people from seeing each other, you would ultimately have to go to a court. You can get a ADVO at a police station, which we'll see later on, which is known as an interim ADVO.
Okay.
It's like an emergency one.
Right.
Yeah. So if, for instance, there's a huge dispute in the household, they end up back at the police station, the senior officer on duty at the time can make an interim order that will then need to go to a court at a later date. But that means from this moment on, you two are to stay away from each other. And if you don't, then we will imprison you. And they can be pretty clear about that to a father or something. And they say, look, if you go near your wife in the next 48 hours, if you make any contact with her, we will come around and arrest you and put you in jail. They can do that. The family court makes orders because I suppose they say things like, look, we don't want the two of you to talk to each other at all. Do not text each other. If you're handing over children for custody, get a third person to do it, get a grandparent to do it. They can make those sort of orders, which really are family court orders about family violence or keeping people away from each other. Sometimes, and this is the thing about having these two systems operating together, and the difficulty of it is sometimes the family court is doing one thing and the Crimes Act and the state ADVO is doing something else. And sometimes they don't even know, or they haven't been properly informed that there's, this is part of the problem that's happened in the past. So under the Family Law Act, and it gives you the section there, family violence orders can allow parties to come into contact with each other who may have an ADVO with each other. So let's say, for instance, a mother and a father have launched ADVOs against each other for various reasons, and the court has ordered that they have nothing to do with each other. The Family Law Act gives some power to say, okay, we understand there's an ADVO against you, but in relation to your children, you can deliver and collect your child. Okay? You can have family counselling together. Those sorts of things. But again, this is where the two systems have to speak to each other and be in agreement with each other. Okay? But the point that's made here is by doing this, by having some contact order that overrules the domestic violence order, it weakens the domestic violence order. Okay? So a woman may say her husband is violent and abusive, and I now no longer have to see him because I've got an ADVO, but then the family court could order that they have to go to, meet each week to hand over the children, and that could be incredibly traumatic, and give the father an opportunity to abuse the mother again. And those sorts of things have happened. Is that making sense? Does anyone want to say anything?
Farmer.
Yeah, Roger.
I'm confused about the last dot point.
Okay, let's read it together. If you have a contact order that gives the father contact on weekends, but the AVO only allows contact between the father and Saturday, you have a conflict about contact on Sunday. The contact order will overrule the AVO and contact will happen between our weekend. what it's saying is, if the two things are in place, if there's an AVO and then the family court makes a contact order, the contact order, which is made in, I suppose, respect to the child and the best interests of the child, at the moment in law, will mean the AVO is overruled. Does that make sense?
Yep.
And I suppose that goes back to the whole idea that federal law, Commonwealth law, always overrules state law. And it's saying whatever a local magistrate has decided is a reasonable amount of contact between the two of you is overruled if the family court think, in the best interests of the child, I'm going to make this order for you to have contact with each other. Is that making sense?
Yep.
Okay. Okay, so let's go to the next slide. We've got about 10 minutes left, so this might be the last slide we do today. Is everyone happy with that? Can I get some response about that? How are people travelling?
Too bad.
Yeah, good round. And what you should be doing now, oh, good to see you, Megan. You've joined us. Excellent. Okay, I'll talk to the class as a whole once we finish this presentation, but we'll just make this the last slide today. Okay, so on the 18th of February, Cabinet approved amendments to the Crimes Domestic Violence Act 2007 to allow police-issued apprehended violence orders. So this is a good example of law reform. So in 2013, police began to be able to make ADVOs. In the past, it was only a magistrate. And this is what I was saying. An ADVO can be issued at a police station now, an interim one or a probationary one.
Mr. Palmer?
Yep, Lauren?
What's it mean by cabinet?
That means New South Wales Cabinet. Now, the Cabinet are the ministers of the government, which means the most senior politicians within the government at the time approved an amendment to the Act.
Okay.
Means it didn't have to be voted on. This amendment to the Act didn't really, well, did it have to be voted on? I'm not sure, but like, it just means, yes, it's going to happen.
Right.
Okay. And I suppose, does anyone want to venture, why are they allowing now police officers to do it? Why doesn't it have to go to a court?
Is it clogging up the courts?
It's clogging up the courts, and it's also meaning that you can move quicker. You know, the police can do it just straight away if they think there's real risk. Now, this goes to what we were talking about before. Let's read through this. An application for an order must be made. Okay, so this is different as well. If a police officer suspects or believes that stalking or intimidation, a domestic violence offence, or a child or young person has been abused, has recently been or is being committed or is imminent or is likely to be committed against the person for whom a protection order would be made, or proceedings have been commenced against a person for such an offence against the person in need of protection. So it's saying a police officer, the senior police officer at the station, if they really believe that a person or a child is in danger, they must make the order. Okay? It's not up to the victim. It's saying, if you as a police officer think this person is in danger, make the order. We'll work out later on if that order was justified or not, but if you reasonably think, you know, if you suspect or believe, then yes, make the order. Okay, and that is another law reform step in an attempt to stop people being violent to each other, and not relying on their judgment to work out what's safe or not. Okay, where there is good reason to believe an order needs to be made immediately, a police officer must make the application for a provisional order. Okay, and that also relates to damage to a property. So they're not giving the police officer, they're giving the police officer, this goes to discretion as well, doesn't it? Police officer has some discretion here. Do they believe the person is really in danger? Do they believe it needs to be made immediately? Yes, they can make the order. Okay. And then down the bottom here, it says the advantages of police making applications include the police make preparations for the application to court, meaning if you have someone who is being abused or being, there's violence in the family, and they have to go to court and they have to prepare documents and they have to think about what they have to say and how they're going to prove it, that often is way too much for the victim because of their situation. So it's saying the police now have the obligation to collect the evidence and take it to court. And that's taking some of the burden off the victim. It's putting more work onto the police, but it's saying we want the police to be active and to make sure these if the police believe and suspect that something is happening, the police will do everything they can to take it to a magistrate, to take it to the local court, to make sure that, something will happen, some protection will be in place. There will be, all police stations now have, and this is another recent law reform, they have a particular person who's a domestic violence liaison officer, so a police person who deals with domestic violence and talks to victims. And so basically the police are being better set up by having liaison officers, by having special prosecutors, means people who represent the government, represent the state to bring these cases on behalf of the victims. And enhanced costs protection means if you bring an ADVO against someone, it doesn't go well, you're not going to be asked to pay any money back or to pay the legal costs of the other person. Okay, it means you're protected really. You can bring the ADVO without anything happening back to you. Private applications do not enjoy these benefits, and similar resources are not widely available to private applicants except at cost. Which means that if the police don't bring the application, if you just do it, if I go out today and I put in an application without talking to the police, without going through the police support processes, I don't enjoy the same benefits. Okay, so it's really putting it onto the police to take a much more active role. All right, and all of these reforms are being put in place to try and make ADVOs more accessible and to support victims more and support and protect children. Is that making sense? Now, next period we'll look more at, do they actually work? Are they effective? But at the moment, I suppose this is all about having a system which is resource efficient, where the systems are talking to each other and where there's accessibility to the law. All right, we might finish this section now. Brianna, if you want to stop recording.